Thank you very much for coming to this last session of our conference, which has been a remarkable set of panels all day long. And appropriately, we decided that it was important to conclude this conference on an issue that's on a lot of people's mind, not only since the beginning of this administration, but frankly, for a very long time. And we are really fortunate that we have assembled, I think, three of the best people in the country to speak on this issue, certainly three among the best people in the country to speak on this. So those of you who are law students or lawyers, the issue of preemption is dear to everyone's heart. And we know, as we learned even in the morning panel today, that on the issue of federalism in a constitutional democracy, immigration is now testing all the parameters that should be tested in that dialogue. This is not a Trump administration issue. I mean, we can give Trump a lot of credit for having brought it to the front lines. But this has been a debate which has been going on at least since the beginning of this century. It even has roots in the 1996 law, the first law in which we allowed local cops to have some role in immigration enforcement. People forget that the present statutory provision on penalizing jurisdictions that don't comply with federal immigration law was a 1996 provision of the law. This has preceded Trump. This has gone back at least in 96, through the Bush, through the Obama, and now to the Trump administration. Issues of what are the limits of federal immigration policy, what are the methods that federal government can use to encourage or penalize communities of law enforcement officers who do not comply with the directives of the federal government. These have been at the debate for quite some time. It is true that with the inauguration of this presidency, this has gained a different kind of saliency. The last time we took there about 36 bills about 100 bills by 36 states and District of Columbia, which have been introduced on one side or the other of cooperation or lack of cooperation with the federal government. This is a very contested territory. Just to keep you informed of our coming attractions, MPI is in the middle of an 8-site study on how law enforcement at the local and state level is being implemented at the beginning of the Trump administration compared to the end of the Obama administration. My colleague Randy Capps is leading that for our institute, and we'll see the report hopefully by the end of this year. It so happens that all three people on this panel have been interviewed for that study, and we're grateful to them. But so just to get us started today, I thought I would just start with Hiroshi. Let me just say one more thing. Now, you all have their bios in your packet, but let me just tell you why these three people are so important to this debate. Sheriff Hall is the sheriff of Davidson County. When I started this work, Davidson County was a big name that came to my attention. It was one of the first major 287G programs in Deep South. He has lived through the creation of the program. He decided to end the program. He saw the life of secure communities and the end of secure communities and the beginning of the new directives. He has seen it up front in a very important state for quite some time. Chief Manger, obviously, is the chief of our neighboring Montgomery County here in Maryland, one of the most important counties in neighboring the capital of the country, where everything gets magnified and everything gets seen under the microscope about how federal law is being implemented. And both of them actually have very important senior positions in the association, both Sheriff Hall as an important leader of the National Council of Sheriffs, and Chief Manger is actually currently the head of the Major Cities Chiefs, which is the organization of police chiefs of major metropolitan cities in the country. And my friend Hiroshi Motomura, by all accounts, is one of our most influential legal scholars in the country on immigration and constitutional intersection. So Hiroshi, let me just start with you. I mean, how did we basically get here? I mean, from a good part of our country's history, I would say from Reconstruction to 1996, it was generally assumed that this is a federal
Yeah.
issue, that
Well-
no one has any role other than the federal government. And then we start seeing 287Gs, secure communities. We started challenges to laws from all across until the state of Arizona passed 1070, which went to the Supreme Court. We thought this had, even after that, been a relatively settled debate. And we know that in this, today, this tug of war between the federal government and the states, it's obviously a political battle. It's about politics, it's about policy. But laws at the state level and litigation at all various courts of the country are the tools now through which this political battle is fought. So how did we get in law becoming such an important element of this debate?
Well, thanks, Moose. Thanks for having me on this panel. It's really great to be here and see so many of you here. Yeah, so you asked me to start with Reconstruction. I was actually going to start earlier than that, but not in real time. Don't worry. I think what we're going to end up talking about today is something super important. I mean, really how state and local law enforcement intersect with federal immigration enforcement on the ground. And I'm really looking forward to what my colleagues from law enforcement have to say about this. But I think Moose asked me to kind of give you some context here, because as important as this particular issue, for example, of detainers and notifications of ICE is, it really comes up against, or comes in the context of a really deep history here. And I'll just hit some high points here. There's a lot more to be said about this, but I think I'm just going to take a couple minutes on this. I mean, one good place to remember, well, maybe not remember personally, but before the Civil War, immigration regulation was largely done at the state and local level. There was not the kind of federal immigration law that we've kind of accepted as sort of the standard view. And it's interesting to think about why. I think one of the reasons why was slavery. At a time when this country did not have a unified view, not only lacked a unified view on the movement of people, but exactly who counted as people and who counted as property, it stood to reason that you couldn't have a federal immigration law. And the Civil War, by elevating national citizenship, allowed national immigration law to take root, and that started no later than 1875. There are people who trace it even earlier, but. So that's really since the late 1800s, we have this view that federal immigration law is supreme. But there's just a lot of uncertainty in that statement. We're not sure exactly what regulates immigration. We're not actually even sure what immigration law is. And so what's happening now with so-called sanctuary jurisdiction controversy, same with what we had with controversy over state and local involvement in federal immigration enforcement, like with SB 1070 earlier in this decade, it's trying to figure out exactly what that means to say that immigration law is federal. I think another thing the history teaches us is that the different sides have switched over time. States and localities have taken different positions and switched their own positions. And we see this very dramatically in this past decade, where a lot of the organizations, individuals, political views that were opposing, for example, as Arizona's enforcement provision, SB 1070, and other provisions, are, to some extent, at least superficially, on the side of folks who might want to have their jurisdictions declared sanctuary. So that lesson is that histories that sides switch over time, and much of the, and this gets back to Moose's premise here. I mean, much of the attention in the last generation has not been on sanctuary in terms of court decisions. A lot of the attention has been on the limits on state and local enforcement, and I'll give you a few examples of that. When you start having the rise of, or the increase in what becomes the undocumented population of roughly 11 million people, you start having states wondering why there's so many people in those states or localities who are without lawful presence, who are in the country illegally. And so you start having laws like the law that Texas enacted in the 1970s to essentially keep or make it difficult for undocumented children to be in public schools. And so that leads to the decision in Plyler versus Doe, which says that the state of Texas cannot keep, on account of immigration status, cannot keep kids out of K through 12 public schools. If you fast forward another 20 years, you get to Proposition 187 in 1994 in California, which cuts off public benefits and really tries to become a test case to try to overturn Plyler versus Doe. And then if you go forward another 10 years, in 2000s, you have a whole bunch of state and local laws that try to go after jurisdictions, to try to make it difficult for people without lawful immigration status to be in their communities. And so that's when you have Hazleton, that's when you have an Arizona law, not SB 1070, but the employer sanctions law in Arizona. I mean, these really try to go indirectly, to fight illegal immigration indirectly by making it hard for people to live there. And I think one of the reasons it did that was because the idea that the immigration law is federal. And so it said, well, we can't regulate immigration, but we are going to regulate housing, employment, and education. So that's why a lot of the state and local enforcement was indirect. But then then you have a move to try to get the state and local police more directly involved in federal immigration enforcement, and that's when you have SB 1070 from Arizona, which was enacted in 2010. And here's why this is so tough. It's because you can say that that immigration law is federal law, but then what about these laws that regulate education, housing, and employment? I mean, that's state authority is traditionally in those areas. Why can't states do that? So that's one thing that went to the courts in the last decade. And another is, like, what is law actually? In other words, is the law is written, or is it the law that's enforced? And so if there's someone who the federal government would not move against, but the local government does want to move against to deport them, is that a conflict is that a conflict between state and federal law, or is that just states filling in the gaps where the federal government has chosen not to act? So in 2012, the Supreme Court in Arizona versus the United States, I think, took a position that radically reduced the room for state and local enforcement of immigration law when it's not specifically authorized by the federal government. And it basically said that federal enforcement policy is federal law, and that it's important that that federal prerogatives be respected, and that if someone wouldn't be moved against by federal enforcement, then it's really not for Arizona to jump in and say, well, we want to go after those people. So I think that Moose is right that a lot of those questions, I think, have been addressed in terms of the state and local role in enforcement, which I think is really limited by the Supreme Court. But I don't think that the states have decided issues regarding what are now called sanctuary jurisdictions. I don't think and I can explain this more later, but I mean, I don't think it's a question of the symmetry. I don't think it's a question of the turf was defined as here's the federal government's turf and here's the state local turf. I don't think the Supreme Court dealt with it that way. And so I think a lot of the issues about what exactly is going on with so-called sanctuary jurisdictions are really quite are quite unsettled. And I think you have to look more closely at why the federal government jumped in the Arizona case. I think the reasons they jumped in don't necessarily apply to the sanctuary situation. And so we're really in uncharted waters, not entirely without some landmarks, not entirely without some precedents, but we're certainly in an area where we're not really sure what some of the constitutional limitations are on that address how far states and cities, local police can go, have to go, and what the constitutional protections are. So, and now, of course, after the election, things have flipped around where politically a lot of the attention has gone to either sanctuary jurisdictions or jurisdictions that are trying to maybe avoid the term, but it actually are doing things that other people would think of as in the general sanctuary. And so that's just kind of how we got, I just compressed, 200 years into about 7 minutes. But let me just stop there and just kind of see where we are in the conversation.
Great. So let me go from the abstract to the real. So, so Sheriff, so how does Sheriff of Davidson County in Deep South think of the right balance between enforcement of federal immigration law, which is important to the national integrity of the country, and to the local safety that you are sworn to do and elected to do? And how have you seen it change in the last 20 years that you had to deal with it?
Yeah, well, thanks for having me too. By the way, I want to say that we were warned we were going to be on the hot seat, but this is hot up here, so I took my coat off. It's before you ask any hard questions. So, but yeah, I think that is the word. I mean, if we could all do something, especially in this subject, balance seems to be what's missing to me, and it's not easy to find. I think when you're elected to do the job that I'm elected to do, and you're sworn to do certain things, and you're a part of what is called law enforcement, that puts you in a unique situation. It's part of it. It's a principal part of law and order, I guess you would call it. But the balance is also to be what we call a welcoming city in Nashville. That's what we want to be. That's what I want to be a part of. I was born and raised there. And you have to find what that balance is. If I had my pure dream, local and state and so forth, I don't think immigration is really what we should be doing. But the difficulty is I'm not very proud of the way the federal government does it either. And so it leaves those of us in the job that I'm in a very difficult spot. And so the public have a general expectation, I think, of the role that I play or I deal with back home, that when we release someone back into the community after their responsibilities are cleared up, whatever they may be, that we're putting them back into the community kind of free of any other responsibility. And up until about 2007, I've been in this for 30 years, so until about 2007, if you stopped me on the side of the street and said, hey, are all these things checked on every arrestee that comes through jails in Nashville? I would have said yes. I would have raised my hand in a courtroom and said, yes, Your Honor, everybody's checked. Because that's the impression and that's the false sense of security that we all lived by in law enforcement. That immigration was being notified of all arrestees even way before. This is in 2007 when I realized it. Because I went to work in 1988. When someone was arrested, we'd call INS. Yikes, that cooled me off here. That's no longer hot. But yeah, so up until that time, we really, well, I made a mess. Up until that time, when a person was arrested in Nashville, Tennessee, we would call INS and say, hey, we have John Hudson here, and he's from Canada. He was arrested. What do you want me to do? I mean, I did that back in 1980s and 90s. And so up until 2007, I would have trusted and did trust that all that was being cleared by the people who knew best, INS. In 2007, it became very clear to me that wasn't happening at all, unless people were committing aggravated felony offenses. That was the only ones that were really being checked. And so I don't want to get into, there's a case back home that really led us to really looking into it. 2 people were killed in a very tragic situation. And I had the individual 13 times brought to the jail, processed, notified the federal government every time. They cleared him to be released every time. And then he drove out and killed 2 people. The community was outraged. The headline said the first day, DUI defendant kills 2 people. The next day, the headline said, killed by an illegal immigrant. Next day, it said, and the sheriff had him 13 times. That's probably not exact, but it's what it felt like. Because the pressure was, why did you let him go? And I told everybody, we checked his status. He was cleared, he was cleared, he was cleared. The truth of the matter was, he was never checked. And the pressure on us was to explain why and then what can we do about it. And so I never wanted to be in immigration. But when you're in my job and you're letting we let 40,000 people a year. We turn them loose back into the community. They're not bad people, by the way, none of them. I'm not judging people. But I am telling the community that they're free of their responsibilities. And so that's the difficulty, I think, that I have found. And I believe it's a hard balance to find, because to ignore it all, I have a problem with that. And to go search for people and round people up, I have a real problem with that. So it's just kind of finding some sort of balance.
So can I just follow up with you? So we know that Nashville went through a difficult time with an ordinance that would have barred you from cooperating with the federal government. And it was finally abandoned, we assume, under a lot of pressure from lawmakers, but from opposition from you too. Why did you decide to oppose it? And what do you think is the best parameter for you to decide whom to hold and whom not to hold? And have you made any different decision in recent times on that?
Yeah, I'm kind of nerdy on stats, and just to kind of give you an idea, we have 40,000 people booked in jail in Nashville. I hate doing this, but I'm going to talk presidential terms. People relate to that. We have turned over fewer people under Trump than Obama, month after month after month. We've turned over 1% of all arrestees to the federal government. 1%, that's 562 people last year. And so my local legislative body tried to pass an ordinance that would disallow me to do anything. And what my commitment was that if that number starts to increase in any level, I'll sit down and talk with anyone, and we'll come up with what is a balance. But they were going the way I don't agree with either, which is to ignore it all. And I don't agree with rounding people up or whatever the numbers were, and we're going to do. That's not where I was either. But to prevent me from doing it, I had some real problems with in principle. And my commitment is that I'm not increasing it. We're not doing that. But what we are doing is, I find it very difficult to say the words, I'm going to not cooperate at all. I think I can decide in our city what is too much and too little as we go forward. But right now, just so you know, it has not increased one bit. And if it does, I'm committed to evaluating that going forward. And I don't love legislative bodies trying to institute policy like that. It was a complicated issue back home, but it's not an easy subject to have with everybody. I don't know. This is why we're here, and Lord knows I've had all kinds of bizarre. I never thought I would get into conversations in my life after 287G and 5 years of that, and then as we continue to operate now. But I do think there's a balance somewhere, but I don't agree with either side to the extreme.
So Chief Manger, so let me move to you, and if you don't mind, wear your hat both as the Chief of McGarrican, but also as in your position as the head of the MCC, which has frankly dealt with this issue for a very long time, has looked at it as really almost policy wonks would look at it in terms of how this cooperative stuff works at the local level. From the perspectives of the big cities, does this balance between federal enforcement and local safety look different and create a different kind of tensions?
One of the issues that large urban jurisdictions, and that is the largest cities in the country are members of major city chiefs. It's New York, Los Angeles, Chicago, Houston, and it's the largest jurisdictions in the urban jurisdictions in the country. Typically, they have large immigrant populations. So this impacts jurisdictions like mine, where 1 out of every 3 residents, so 1/3 of our residents, were born in a country other than the United States. So we have a large immigrant population. I think in New York, it's 4 out of 10 of their residents were born outside of the United States. So the policy and the practices that law enforcement in these jurisdictions has with immigration enforcement matters. It matters a great deal. If you have a significant segment of your population that doesn't like or trust or fears the police, they're not going to come forward to report crime. They're not going to come forward as witnesses. They're not, and this inherently makes the jurisdiction less safe. You have more unreported crime, the jurisdiction is less safe. So for police chiefs, and let me just say that one of the differences between the sheriff and I is that he is elected every 4 years. That gives him, during his term, he has authority to do what he wants to do. And if people don't like it, they can choose when he goes up for re-election to make that decision whether they like how he's enforcing the law in his county. For me, I serve at the pleasure of the chief elected official, whether it's the mayor, whether it is the county executive. I serve at the pleasure of the chief elected official in the jurisdiction. And so I'm not making policy. I mean, I make policy within the police department, but a lot of the decisions about how immigration, the level of cooperation between law enforcement and the federal government is impacted by decisions of elected officials. And so, the struggle that I've had as a police chief for the last 19 years is the way the landscape has changed. When I began as a police chief in 1998, I can tell you I went weeks, months without thinking about immigration issues, and when they came up, it was pretty infrequent. After 9/11, things changed. In early 2002, then Attorney General John Ashcroft decided that he was going to put civil immigration detainers in NCIC. NCIC is the database that police rely on every day. When I stop somebody for running a stop sign, I check their license, and I run them through NCIC to see if they're wanted anywhere in the United States. Now, before Attorney General Ashcroft put these civilian detainers in the database, it was typically criminal charges. If you were wanted for a crime, not a civil offense. So this changed things because as a police officer, it's different for sheriff's deputies, but as a police officer, I have no authority to enforce civil infractions, none. I can enforce criminal law. I cannot enforce civil violations. And except if it's, they can make exceptions through the statute, but in general, criminal enforcement only. So all of a sudden, my cops at 2 o'clock in the morning, when they were stopping someone, would get a hit in NCIC saying the person is wanted for an civil immigration violation. Well, there was a question as to whether my cop had the authority to do anything, detain that person, take him into custody, and this was a new problem, a new issue that we had to tackle. So fast forward a few years, and you've got 287G. Where it would make sense, I think, and did make sense for folks that may have been in the corrections business, as the sheriff is. He runs the jail in his county. Not only does law enforcement, but runs the jail as well. I don't run a jail. And so for police departments, less than 1%, and you all know there's 18,000 law enforcement agencies in the United States of America, 18,000. You've got New York City with 40,000 cops. You've got plenty of Andy of Mayberry, and half of you aren't even old enough to know what that means. But you've got a lot of police departments that have under 10 police officers. You've got this issue about 287G. Less than 1% of police departments decided that they wanted to opt into the 287G program. In fact, I think it was about 400 police departments or law enforcement agencies out of 18,000. That's a pretty low percentage. Then came along secure communities. And secure communities was okay because they said they were targeting serious offenders, and then it turns out, well, they weren't. They were sometimes, but weren't other times. And then they morphed into the Priority Enforcement Program, PEP. And I can tell, from my perspective, that was the best they had going. Under the Obama administration, the Priority Enforcement Program said, these are the category, if you arrest somebody for these category of crimes, these are the folks that we're interested in looking at in terms of deportation. And these were serious offenses. And I thought, okay, this makes sense. We only have so many resources to deport people. Let's focus on the people that are committing the most serious crime. Then under the new administration, we went back to secure communities, and then we got into, you had to prove that you weren't a sanctuary jurisdiction, and who knew what the definition of a sanctuary jurisdiction was? That was all over the map. And then then for a brief time, the administrative got into the name and shame game, where if you did not honor a detainer, they put out a report to the public saying, this jurisdiction didn't hold this person, and if that person was arrested again for another offense, they made a report, made it public, put out press releases announcing that a sheriff or police chief had released someone who then committed another crime. And so this is the landscape, and I share that with you because this is the landscape that local police have had to deal with. So what we're trying to do, and I agree with the sheriff wholeheartedly, we're trying to find a balance. What we care about is keeping our community safe. And there is a balance there. On the one hand, if I'm the immigration police, I lose a significant segment of my community that's going to go into the shadows, not cooperate, not report crime. That's not good. That's not good for public safety in my jurisdiction. So if I go to the other extreme where I am a sanctuary jurisdiction, that when we arrest someone, now by policy we don't ask anyone about their immigration status. We don't ask. We don't care. When they get to the jail, what happens with the corrections department is different than what the police deal with. But people sort of lump all that together. It's in fact corrections where they play a greater role in terms of dealing with ICE. So you've got folks that say you shouldn't be asking anyone about their immigration status, and when ICE inquires about someone, you should not respond. And when ICE inquires about when they're going to be released, you should not respond. True sanctuary jurisdictions, and there are a few. There are relatively few, but there are a few in this country. So here you've got something where you could have someone who is a career criminal, a repeat offender, and you have the opportunity to work with ICE and perhaps get them deported out of your community. And frankly, there's some people in my community that I don't care how I get them out, if I can deport them, put them in jail, my communities, my neighborhoods are safer. So that's where you got to find the balance. And the folks on both extremes, so we have an organization called Help Save Maryland. They're not very nice to me, and they say mean things about me. And you have some immigrant advocacy groups that wish we would not cooperate. The county would not cooperate with ICE. And here's what we do. This is our cooperation. My cops arrest somebody. If they are arrested for an offense that requires them to be fingerprinted, those fingerprints go to the FBI. FBI shares them with everybody else. If ICE determines that they are interested in that person, they will call down to our jail and ask our corrections department, do you have this individual in your jail? We will say yes or no. And then they say, all right, if the answer is yes, when is that person being released? And if we know the release date, we'll give them the release date. And if they want to be standing at the door when that individual's released, ICE can take them into custody if they want them. If they say, well, we're going to file a detainer, and I know they're going to be released, next Wednesday, but we're not going to be able to pick them up until Saturday. So can you hold them till Saturday? No, we can't. We won't. There's case law in the Fourth Circuit that says we cannot hold someone beyond the time when they would be normally released. So if ICE wants them, they got to get them when we release. That, I believe, is the right balance. Again, there's folks that on both sides that don't like that, but frankly, I think that that's the right balance for public safety.
Chief, let me just on your last point before I go back to Hiroshi. So what are you doing to sort of place trust in the community for the work that you do, given the political landscape?
We spend a great deal of time doing community outreach to places where we don't typically get invited. I mean, if you've got a nice homeowners association that invites my cop to come in and talk to them about what's going on in their neighborhood, usually a very pleasant meeting. They talk about some of the crime issues, that sort of thing. But these people will, trust the police, and they work with us and cooperate with us. I like to go to the meetings where the folks aren't enamored with us, where there are trust issues, and they do have concerns about the way they're policed. And if there's one thing I've learned after 40 years of being a cop, I can talk all day about how crime's down, we're seeing this and this. People could care less about the crime statistics. What they care about is how are they treated by their police department. If they feel like they're treated fairly, treated well by their police department, that matters so much more than any crime numbers that I can recite to them. So community outreach, where we talk precisely about what our policy is. We don't ask about someone's immigration status. If you are reporting a crime, don't worry about a police officer coming to your door and taking asking for your name and your address and your phone number and other information that they need for their report. We don't care about your immigration status. We're not going to ask you about it, and nothing that you tell us is going to be reported to ICE. We make sure people understand that you can, and we want you, when you need assistance, we want you to call the police. We are your police department. We're there to help you. We're not the immigration police. We don't care about your immigration status. However, if you commit a crime if you commit a crime that is serious enough that you get fingerprinted, and I'm not talking about a parking ticket, I'm not talking about a traffic citation, I'm not talking about, possession of marijuana, a small amount of possession of marijuana. We'll write you a little citation and send you on your way. And those citations don't go to ICE. But if you are arrested for something serious enough to be fingerprinted, then you do risk ICE finding out about your arrest, and if they're interested in you, you do risk them inquiring about your status. So that's not a police issue. That's a corrections issue. The sheriff has to deal with that because he runs the jail, so he's got folks that have to deal with that. But if you let people know that if you're not out committing crimes, that you have nothing to worry about, that goes a long way in terms of alleviating some of the fear. But I can tell you that with the changing landscape, how it's impacted law enforcement, the changing landscape from the Obama administration to the current administration has absolutely sent shockwaves of fear through our community. And we've had to try and tell folks over and over and over again, and I repeat this message all the time, nothing has changed of the way we police our community. Nothing has changed.
Well, that's good to know.
Well, if you like the way it is, it's good to know.
So back to you, Hiroshi. I mean, away from Civil War and Reconstruction to the present day. So what is the present state of law on the attempts to penalize so-called sanctuary cities? And what is the present state of law on how much the detainers are binding on local jurisdictions or not?
Yeah, there's a couple ways to answer that, and I think they overlap. But one way to answer it is to figure out sort of what is it about the law that puts local law enforcement in a really tough spot. I think there's some aspects that are worth addressing. So I think what local law enforcement really has to heed in terms of constitutional rights. And the other way to answer your question is to focus on the pushback against sanctuary jurisdictions. And there'll be some overlap, but I just want to mention a couple ways to kind of think about this. Let me first say spend a couple seconds on why the law, what legal rules apply to a situation where local law enforcement has reasons to comply or not comply or comply somewhat with federal detainer requests. I mean, the one that keeps coming up, and we've had some case law on, is the Fourth Amendment, constitutional protection against unreasonable searches and seizures. And the concern here that courts have expressed is that there's no finding of probable cause under supporting an ICE detainer, and this is the reason why the ICE detainer is a request and not a command. And there's some cases of a lot of liability for local jurisdictions, so that's one constraint. Another constraint here is the 10th Amendment. The 10th Amendment basically, part of it says that the federal government cannot take over local and state functions and say, we'd like to have this group of personnel do something that we don't want to pay for, but we want you to do it. And so that's another thing that's relevant here. And the third thing, which is, I think lurking in the background, it deserves to be named, even though I think that I would hope that these are more, this is not something you're going to see. Well, let me just tell you what it is. It's that the question that I think Cecilia Wong raised in the last panel about racial profiling and skewed law enforcement. And I think that one of the concerns lying against the background here is that either takes place or it might take place and you won't find out about it. Okay, so those are some of the legal principles. And so let me move to your actual question as sort of federal responses and trying to push back on this. The executive order that the administration issued, sort of pushing back against sanctuary jurisdictions, basically said that we're going to penalize sanctuary jurisdictions. But there's a lot of vagueness to it, so much so that I think the courts that have dealt with this have had a hard time figuring out actually what it requires beyond current law. But there are some limits limits to what the federal government can do to force jurisdictions not. Or I'm sorry, let me start that sentence over. There are limits to what the federal government can do to require cooperation. And here are some of them. One is something I just mentioned, which is the Fourth Amendment, that you can't have the federal government asking local law enforcement to put themselves in a position where they're violating people's constitutional rights and having to pay for it in damages actions. Another is that the federal government can't tell the state and local government what to do. And there's a lot of case law on this that has nothing to do with immigration law, but it has to do with other times when the federal government has tried to get the states to do something. Another is something that's come up that's come up recently too, which is an attempt to condition federal funding on compliance with federal immigration policy. And there are a couple of limits here that are worth noting. I mean, one is that Congress can set certain conditions, but it's not for the president to come in after the fact and impose additional conditions. That's really a separation of powers problem, and that Congress might have been able to put some conditions in originally, but that doesn't mean the president can do it after the fact when the money's been appropriated, for example. And the other is that Congress cannot impose coercive conditions. This came up in the Affordable Care Act case, where Congress tried to get states to expand Medicaid funding, threatening to withdraw the funding, and so that ran into constitutional problems because that would be a coercive condition on federal funding. So there are limits that are set out in the constitutional protections that the federal government would be forcing state and local government to violate. There are limits on how far the federal government can ask states and local governments to do anything. And there are limits on the use of the funding power. There's something called, there's a law called Section 1373. It's often talked about, and it's invoked by this administration quite a bit. But actually, it doesn't really constrain. Constrain these kinds of sanctuary provisions that much. I mean, it's really quite limited in its scope. And so many of these cases, it doesn't really do what I think that this administration wished that Congress had it do. Let me just add one other thing here before I turn it back over to other speakers, is that there's a reason why these provisions exist, especially the 10th Amendment provisions protecting state and local decision-making against the federal government saying, you do this, and if you don't do this, we're going to take away money. There's a reason for that, and I think a lot of what's going on, and this may be reflected in some of the call for sort of the dilemma that Sheriff Hall talked about, is that to me it feels like this is one of those cases where the federal government wants the state and local governments to do what the federal government won't fund and won't have a debate. And in other words, one of the purposes of not allowing the federal government to require state and local governments to do something is because if this is something that needs to be done, Congress should pay for it and should make that decision. It should be done transparently, and debate should be about this. And so, one way to look at about the protections that local government has in this to push back against federal pressure is to say, well, if you want us to do it, you fund it, you have a debate about it. Don't ask us to do it without and impose it on us and skew our own community's discussion about what our priorities are. And those priorities are going to vary from community to community, but there's a certain degree of local autonomy that the states and cities are invoking in the jurisdiction. And one thing that's also interesting about the politics of this is that I've seen, not just in California, but throughout the country, is there's certain jurisdictions that are really taking the lead on saying these are our local prerogatives, and we're going to insist upon them. And so what's actually happening in many jurisdictions is that jurisdictions that are maybe a little bit more concerned about the cost of litigation, about the risks they're taking, they're really relying on the lawsuit, for example, County of Santa Clara and City and County of San Francisco against Trump. They're relying on the litigation in Chicago and seeing what will happen. I will go back to something that Moose said earlier, which is that a lot of this stuff is really unclear what the scope is of these of local decision making, and I think that this is something that, like many things, it may take going to the Supreme Court, although maybe not. We just don't know.
So both of you, could you just quickly react to what your thinking is on federal government penalizing jurisdictions which don't fully cooperate?
Yeah, the federal government has a lot of work to do to fix their own systems. You know, that's, to me, that's my problem with a lot of this. It's just one little thing about that. I think Chief Manger mentioned a minute ago the NCIC, which is basically universally accepted as a trusted criminal justice information tool. Everyone uses it to check to see where you're wanted and what other charges you've been convicted of. I hardly ever hear people, I don't think I ever have, question, you know, its validity. And ICE is so far away from having their system to an equal level of trust. And so when I hear some of the threats that come out of Washington about what we need to do, keep in mind I don't agree with ignoring the federal government, but I don't like unfunded mandates and other things, because the federal government has a lot of work to do to get their own house in order, and that's, to me, that's an important part of this discussion. So can I talk about secure communities for a second?
Can I ask you that? You can ask weave that into the question I was going to ask you in any case. You decided to close down 287G program. We're now back in the situation where you could go back to 287G. There's encouragement being done by this administration. Are you thinking of going back to 287G, and if not, why not? And then you can weave in secure communities in that.
Yeah, so real quick, 2007, I mentioned the case earlier where we realized that there wasn't really checks going on at all of any of the releasees, people being released unless you committed murder or rape, basically. And by the way, I want to leave you with something about that. I'm really weird, all right? I don't understand why you check someone's immigration status who has been arrested and probably would be convicted of murder or rape. Why are you doing that? That person's going to serve 60, 70 years. Deportation in 70 years is not going to look like whatever we're talking about today. I believe that's the worst thing people say. I hear it all the time. I think we should only be checking the serious. I'd just assume not check any. That doesn't really make sense. Your community is not safer because you check someone's immigration status who has a 60-year sentence for rape. That doesn't make any sense. I mean, I don't know why people say, and that's kind of a political thing people say a lot, well, I think we should only be checking real serious violators. That makes no sense. I think you should ignore them all as a better answer if that's what you prefer, because that person's going to prison most of the time. So we were in 287G, as was mentioned, because of a case, and we realized that no one's status was being checked. We started that in 2007. We went through 2012. The truth was the foreign-born arrest in Nashville had tripled in 5 years. So we see that on the rise, and now we hear that the federal government has been fooling us all, at least back home, that they weren't checking the status. So 287G, which was in 1996, Clinton, we have to talk presidential, Clinton, 1996 issue. 287G, we were the fourth in the country to do it in Nashville, and we wanted to do that because of the two issues we saw heading our way. Foreign-born arrest, I have no idea their legal status at the time. Foreign-born arrest is all I could tell you. That had tripled in the last 5 years, and so too now I'm told no checks were being done unless you committed murder or rape. So that's what led us there. Over the next 5 years, we ran 287G as a contract for 5 years, and we had a choice. I had a choice to make at the end of the 5 years. The foreign-born arrest had dropped below, I guess it was down to like 4%, which was nothing. And there was no reason to continue to do it. It was expensive. We had to hire our own staff, pay our own staff. There was other issues with it. But also at the same time, the nation was having this conversation about this thing called secure communities. Now we're into Obama, okay? I'm just talking terms. We're through Bush, we're now in Obama, and we have this thing called secure communities. And everybody that was doing 287G was being shamed into anything but 287G. You know, we want you, I had ACLU, which were friends of mine, a lot of folks, maybe not all the time, they weren't friends of mine, but they're friendly to me, and we're friends, but some of this was tough. And they were screaming, you know, get out of 287G, we want you on secure communities. And I said, you're not going to like it. You're not going to want it. The reason is every person's fingerprints for every charge, as the Chief mentioned earlier, is now shared automatically with immigration. Okay, that's millions and millions more people than they ever knew about before. So if you didn't want anyone notified, don't talk people into going to secure communities. But the worst thing it did, and it still does today, is there's a huge misconception about what happens. The truth is, the immigration system's information system only knows about you if you've had a run-in, i.e. a conflict, or been removed from the country before. So really, all we're doing is checking people against a system to see if you've ever done it before. Well, you would never pull someone over for DUI and say, had a DUI before? And if they hadn't, you let them go. You'd never do that. But what do? We check this immigration system, which is totally false. And then we say, they're not in there, so nothing's wrong. We did a study when I was doing 287G that 50% of the people who were in the country illegally coming to jail were already in the system, and 50% weren't. So if I came in the country illegally and committed 20 crimes, 21, 22, 23, and I'm not in the immigration system, we are releasing them by the millions today. So it's a total false sense to if you believe you should check it or not, it's not doing anything. It's really not a very good system at all.
Mm-hmm. So Chief, the same question. What do you think about penalizing jurisdictions that don't fully cooperate?
Well, the Major City Chiefs Association early on took a position that we do not believe that any federal grant money should be contingent on any conditions like immigration enforcement. They have conditions all the time about different training issues, policy issues, and there's certainly conditions that make sense. But for someone to try and strong-arm a locality to get more involved with immigration enforcement, we've absolutely opposed to that.
Right. So as long as I have you, I want to talk a little bit about the unaccompanied minors in your county. This has been a home to a number of them. It's a situation that's closely watched. What special programs, protections do you have towards them, this population? And related to that, there's also been some talk of some people being targeted for their involvement in the gangs, and how careful is the county being in seeing that not all unaccompanied children are potentially branded as guide-bangers?
Well, I think that the unaccompanied minor program is really not something that's in my lane. So let me just preface my remarks by saying that. But what I have been able to observe over the years, because we've had a fair number of unaccompanied minors that land in our jurisdiction, is that very often they're placed in the home of a family member or someone who's willing to take responsibility for them, but in reality they're not. They're not given the appropriate supervision, appropriate care, appropriate assistance. They're enrolled in the schools, and the schools, I think, especially in my county, do a wonderful job at trying to give wraparound services to these kids. But the kids got to go home sometime, and they're very vulnerable. These kids are very vulnerable to gang recruitment. They're vulnerable to just abuse of any number of kind because they are here alone. The lucky ones have somebody to care about them and actually watch over them and try and help them, guide them to make healthy choices. But there are too many that there really aren't. They don't have someone who is guiding them. They someone who signed a piece of paper to allow that person to be transferred from the federal government to the local health and human services folks. But in reality, they're not getting the care, supervision, and help that they need to thrive once they get here. So it's a very difficult situation. I think that, and we've talked a lot about at the local level, how we might be able to do a better job. The schools are very willing to do whatever they can, but as I talked to the school superintendent just a few days ago, I said, unless you can keep these kids 24/7, they got to go home sometime, and that's where they're really vulnerable. And you know, I think there's a great deal of concern, justifiably so, that kids are being labeled as gang members. Well, I can tell you that there are guidelines from the federal government that talk about how a person can be labeled a gang member, and to the point where they're put into a gang database. And I think we try and do as good a job as we can to make sure we're not being arbitrary about who goes in, that you really have to have some solid evidence to end up getting a person, to being able to put a person's name into this gang database. It's not a perfect system. I will be the first one to tell you, but you've got to. But we try and use good judgment and to make sure that the people that we put into this gang database, we have solid evidence that in fact they're engaged in criminal activity as part of a gang.
Okay, I think in 2 minutes we'll start taking questions from the audience. So those of you who want to go to the mics, please do, till I give Hiroshi an opportunity to answer my last question. So having started this morning as to where this debate is, where do you think we are headed to this legally? Is this all going to go to the Supreme Court and Justice Kennedy becoming the decider-in-chief again, or?
You know, I'm not very good at this prediction business, I have to say. But if you think about the key issues here, you've got some fundamental Fourth Amendment issues, and that's kind of a staple of the court's business. More on a landmark level, I think, we've got some basic issues about basic federalism issues of the same kind that we've had emerge with the Affordable Care Act, with gun control and many other things. And so it's one that may be seen as kind of a transcendent issue in which the court may feel a need to weigh in. I think there's also this question of what the Supreme Court decision in Arizona versus the United States in 2012, what it meant. You know, I said earlier that I didn't think it actually settled issues relating to sanctuary. I mean, it's possible the court would have a different view looking back on its own decision, but that may also be a reason why the court takes it. But, you know, there's so much pressure on the court to take all kinds of things that I'm not sure. But it is definitely one where there's a tremendous amount of uncertainty of the kind that the court often feels the need to settle, and it's not just in the immigration area, but it's really having to do with the relationship between the federal government on the one hand and states and localities on the other. The other thing that maybe increased the pressure to take the case is we have jurisdictions that are enacting at the state level, I suppose you could say, anti-sanctuary measures that try to crack down on sanctuary cities within that state. So, for example, we have SB 4 in the state of Texas, and that raises a similar set of issues. So there's a lot of pressure to take this eventually, but it will percolate for some time before I think that happens.
Great. On that note, let's start the questions. Professor May.
My apologies. I keep coming up here with questions. You all gave a very good description of how the process works, right? Somebody's arrested, you know, you don't ask, and they go to jail, and then the data is given over, et cetera. And you seem to be describing what people are very much concerned about today in terms of the detainer policy and people who are already in the ICE system because there's an outstanding warrant or deportation order. I'm interested in knowing how the process works under IRA, right, which seems to be a different thing. These could be legal immigrants with no deportation orders because they're here legally, but they violate the 1996 law. They become liable for deportation because they commit one of a list of so-called aggravated felonies, which could be 2 DUIs, right? So if you bring in somebody on a second DUI, what is the mechanism by which you report that person for removal because they have violated the IRA. You're following
I
me?
am.
Right. So this seems to be, so I guess I have two questions. One is, what proportion of immigrants that are turned over to ICE are those who are people who have existing warrants for deportation or orders, and what percentage are IRA removals? And then what is the process by which you process IRA removals? Thank you.
Yeah, so here's the way I like to think of it. We're going on what the federal government gives us, and the word detainer has been used a lot today. The other issue that we were mentioned just a second ago is there's a thing called a 203, an order to detain, which is really what we are requiring in our hometown now. We're not going by just the detainer, beginning October 1st, which is a big legal issue flying around the country. But the point is this: I'm not in a position to tell you what the immigration violation alleges from ICE. Often they don't even tell you that. And by the way, that's not unusual. Federal government, U.S. Marshals won't even tell you what's going on with inmates they drop off with us. So the feds are very difficult with that kind of information. So I'm not, in the sheriff's role, I'm not authenticating what they're alleging. They're telling me they have a warrant or order to detain for this person, and we're doing that. The courts in immigration are going to decide, the way I look at it, whether the person has violated the 1996 or the IRA, either one. No, it would go through the immigration court. If I understand what you're saying. I mean, I'm sorry? Yeah, if you're asking me when the immigration individual is being charged with a violation of immigration law, is that what we're saying?
No, he's.
I'm asking you, how does the mechanism work if a person has a second DUI or a second shoplifting charge? They are considered for mandatory removal. So how does that, when that second conviction of a misdemeanor falls under the category of an aggravated felony, how is that person then removed because they're convicted in a local setting? So I'm
Yeah. So
concerning from gleaning from this is that that happens at the point where the judge convicts, where a court convicts the person.
yeah, in my state, a second offense DUI is not a felony. So I don't know if that's okay. So so what happens is every booking of every arrestee, this first DUI, second DUI, that's all an automated, secure communities sharing of information with the federal government. Then the next thing would happen is the federal government would send me either the warrant and the detainer, and now the 203 to detain the person upon completion of the local charges. So when the DUI time is up or the bond is made, then that person would be turned over to ICE upon conclusion of those two things. If I don't receive information from the federal government, I'm turning everybody loose. I don't take that information from court and share it with the federal government. I wait on them to tell me if they want to hold them or not.
So basically, the federal government would have to place a detainer on him for them to get, so that they could then put him in immigration proceedings.
Right.
And he would have to decide whether to honor the detainer or not.
Right.
And I think what you just heard the sheriff make is some bit of news, is that they've decided in Davidson County the detainer is not enough. But if they get an additional piece of document called 203A, that is sufficient for the sheriff to hand over that person to federal detain. And that's a significant piece of news. So let's go to this. Sir? Well, there are three people here. Can I just take this?
Very well. I'm Brad Peabody. I'm an attorney and a part-time law professor. I have a question for the sheriff and the chief. ICE takes the position that a courthouse is not a, quote, sensitive location, like a church, a funeral, a wedding, that sort of thing. So you're in the position in law enforcement of having to persuade the undocumented and their relatives to parade right under the nose of ICE and assure them that ICE is not going to do anything bad to them. That interferes with your ability to get convictions. Do you agree that a courthouse is not a sensitive location? And the second part of my question is, have your associations considered taking a position on this? Thank you.
We have not taken a position on this. I had a discussion with Tom Homan, who is the acting director of ICE, and he told me that the only time that they will go to a courthouse is when they know someone's going to be there that they have a warrant for and they haven't been able to get them anyplace else. Now, you can believe it or not believe it. There's been enough instances of folks being picked up at our courthouse. Not a lot. It doesn't happen every day, but it happens occasionally. But I will say this, that he also assured me that they are not there to randomly look for people. He said they go there when they have a warrant for a specific person that is due in court. Again, this is what I've been told. So I don't want ICE telling me how to do my job, and so it hasn't impacted us. It would impact the sheriff because he's doing court security, and if folks start not showing up because they're worried about this, that is an impact that is harmful to our jurisdiction.
I just want to say one thing. I think I mentioned I'm a nerd about data. Just so you know, the evidence is not there that foreign-born people who are issued court appearances are less likely to appear in a courthouse because of immigration enforcement. We did it before, during, and after. And I'm talking about 287G, where we were almost daily in the news media about issues, and of course the word was out we were doing 287G, and we were in the courthouse. But there's no data at all to support that in my jurisdiction, that when we were enforcing immigration law through 287G, the percentage of people foreign-born who failed to appear in court did not go up at all then for 5 years. And so I believe there's a general distrust of law enforcement from the immigrant community, and whether you're enforcing it yourself or not, it's a distrust. And I don't think that starts with a 287G program or others. It started before us, and it still goes on at the same rate.
Ma'am, go ahead.
Yes, this question is for Chief Menger. My questions have to do with the gang database you referenced earlier, specifically with respect to unaccompanied minors or unaccompanied children. If you can explain a little bit about that gang database, the name of the database, the minimum age at which a child's name would be referred to the database, and clarify for me whether you were saying that a child would only ever be referenced or sent to that database if the child has committed a crime that warrants being sent to that database, or is it something that would happen within schools where a school officer might decide that a child should be labeled as having indicia of gang membership that would warrant then a reference to that database?
Most of what you asked, I don't know the answer to. I could get the answers for you, and if my my director of special investigations who oversees my gang enforcement stuff, if he was here, he could recite to you what the criteria are and give you the age and that sort of thing. I apologize. I don't know the specific answers to those questions. But what I do know is that, and I've read the criteria, and they are not, it's not if you've got a red handkerchief hanging out a red bandana hanging out the back of your pocket, that, oh my gosh, you must be a gang member. I mean, there's got to be, and it's usually a combination of things. It's not just one thing. Now, you do have folks that actually self-admit to being part of a gang. You can't just have a specific kind of tattoo and that be enough. It's usually multiple things that will end you up in a gang database. The school resource officers in the high schools are not the ones putting people into the gang database. We have the detectives who work out of the gang unit who are well versed in the criteria to make sure that we meet that criteria. Again, I wish I could cite for you the specific where that criteria is listed, because it is public information. But I apologize. I don't have all the specific information you're asking for.
So it is not just a result of a communication from a school official who may have decided that a child seems to have indicia?
No, absolutely not. There's got to be more information than that. I mean, even if let's say we stop a car that has several gang members in it, and there's someone sitting in the car who isn't in the gang database, we're not going to just automatically put them in the gang database because they're with other gang members. However, if they're with other gang members They are dressed in a certain way to indicate gang membership and have a tattoo indicating gang membership, that might be enough to get them in the database.
Great.
Thank you.
Let's go down here.
Good afternoon, guys. I don't want to take up too much time. My name is Rob Harvey. I'm a student at Georgetown. I'm also a Border Patrol agent active, so I kind of have been dealing with this for a couple decades. But the back and forth stuff especially, I know what you're talking about. A couple questions. One to Chief Manger. You said something about that 18,000 PDs across the country and only 400 of them signed up for 287G.
This was back in when it was back in '07, I think.
Yes, sir. You also said something about most of the immigrant communities being in large cities. How many of those 400?
Well, I was talking about that most large cities have, large urban cities have large immigrant
Good
populations.
copy. How many of those 400 were in communities that had large immigrant populations?
How many were elected to go to 287G?
That would have, where they could really get, pardon the most bang for their buck.
My recollection, and I'm talking about the major city chiefs,
Yes.
which are the largest 70 police departments in the United States. I think Las Vegas joined. I'm not sure.
Well, LA was the largest,
LA sheriffs.
and Davidson County
yeah.
at that time. They were the three largest.
So it's just a couple.
I can kind of help. And one thing, if you don't, and you would know this, but one thing you have to remember, and here's something we said, by the way, I want to call it a green room. That's pretty cool. They put us in a green room. I don't really know if I'd ever been in a green room, but Chief and I were back there. We were debating whether we're going to arm wrestle or fight or whatever, but
No. That's how I got there.
Yeah, I told him, I said it's a rough crowd. I'm not going out there. Here's something to hang on to. I learned this in the last 10 years. The reason police chiefs and sheriffs have somewhat of a different view of this subject is because police chiefs don't have custody responsibility. They arrest and drive away. Their job is tough and dangerous, but it's not super complicated after that. Right? We get sued, right? They do their job and they go back into the community. It's not. At first, I was really mad at them. All right? Years ago, I thought, I can't believe that. It's law enforcement. What are they doing? It's because police chiefs and police departments don't have to worry about the releasee that you just said is free to go. So I love police chiefs. I'm not one. The difference is the reason you feel a tug sometimes, and a lot of times immigrant advocates use the police chief's words against us. Law enforcement said that they're not for it. Well, no, they're not for it or against it because they don't have to worry about it. They don't. So the detainer issue we're talking about and the world that you're talking about, 287G, the reason police chiefs didn't do it, they shouldn't do it. It was really about booking and enforcement and housing. I could name almost all of them. I mean, Orange County, Houston, Texas, Tulsa, Oklahoma, Charlotte, North Carolina, Nashville, Tennessee, most of the Florida, Atlanta. I mean, everybody was moving in the larger cities towards 287G, and then, of course, elections and everything else changed a lot of that.
So with two speakers, we have almost run out, but could you ask your questions? We'll get quick responses, and then we'll conclude. Is that okay? You start first, sir.
Definitely. My name is Lonnie Ellis. I work with the Catholic Church in advocacy around immigration. And so my question regards anti-sanctuary bills at the state legislature. I see in most cases that I'm seeing the police departments, the chiefs and the sheriffs are against these. But are you seeing many where they actually do embrace like this kind of like SB 4 in Texas type legislation? And what would the reasons be that the sheriffs and the police chiefs would be for it?
Ma'am?
Hi, I'm Karen Anderson. I work as an interpreter on immigration law cases, and I live in Montgomery County. My question is for Chief Manger. There was an article in the Washington Post in August about a crackdown on MS-13, and it quoted ICE's Assistant Director for Investigative Programs as saying that ICE officers have been regularly embedded with local police departments, and I wondered if you could comment on whether that's the case in Montgomery County or in other jurisdictions that you're familiar with.
Well, I can, I'll start with you, and no, ICE is not embedded with Montgomery County. I have 2 police officers that are on ICE task forces, and in the memorandum of agreement that I have with ICE, it says that they will work customs enforcement cases, they'll work drug cases, they'll work human trafficking cases, smuggling cases. They will not work immigration cases. So we've got, because we didn't want our folks involved in immigration investigations. So, most, I don't know of any agencies within the Washington metropolitan area where ICE agents are embedded. Typically, where they're embedded is in jails. That's where it makes more sense to embed them. If but I'm not aware of any place. But I really can only speak for Montgomery County. Sir, to your question. The issue, there are many jurisdictions. Chicago is one. San Francisco has actually sort of changed a little bit over the years, but Mayor Emanuel stood up and said, we are a sanctuary jurisdiction, and we're proud of it. But when you got down to it, and they really, it's a very, people, it means 100 different things to 100 different people. And until the federal government got specific and said, well, here's what, if you comply with 1373, then you're not a sanctuary jurisdiction. If you don't comply with 1373, i.e. you restrict information between your jurisdiction and ICE, then you may in fact be labeled a sanctuary jurisdiction. So I don't like these bullying tactics that the federal government would use on anything. I mean, what's next? That the federal government decides there's too many people cheating on their taxes, and so they say, well, we want police to start enforcing, tax law, and and immigration law is more complicated than tax law, in my opinion, and so the fact that things got out of control. By some folks' definition, because there's too many undocumented folks here, there are too many people coming across the border, and it's having an impact on social services. And I know you want a short answer. All of a sudden they say, "Oh my God, well, how about, hey, let's let the police, let them help us. There's lots of them. And nobody's interested in doing sweeps, of day laborers in front of the Home Depot. No, that's not our job, never has been. And frankly, those folks are here to make a better life for themselves and their family, probably not committing a lot, any crimes. And so I got bigger fish to fry than to deal with folks like that.
Okay, before I thank our distinguished panel, this is the end of the conference. Let me do some field thank you. Thank you, first of all, to all of you for staying with us through this day. This has been an extremely, very, very useful conference, and hope from our point of view, and hope you found it too. I want to thank our co-hosts, the Georgetown Law Center and Clinic. I especially want to thank Andy Schoenholz, Jean Atkinson, Jill Bussey, Emily Hawk, Deputy Jill Latta, and my own colleagues, Michelle Mittelstadt and Lisa Dixon, and the stars of our interns and COM who make this thing look so seamless. And please help me say thank you to Sheriff Hall, Manger, and Professor Montara. Thank you.